but that was Senate Bill 1017. Next, we're going to talk about a bill that was, I want to say affectionately, but quite the opposite, a bill that was derisively nicknamed the Death Star because of its just absolutely obliterating effect for city and county authority. And this is House Bill 2127. And what this bill has done, or has attempted to do, is what is known as field preemption, which is not a concept that we had in Texas previously. It identified 8 areas of state code, and it said this entire field of law is preempted by state law, and local governments have no authority to regulate in this area. Excuse me. All of my children have strep throat right now. I think I'm avoiding it, but I'm a little scratchy, so forgive me. So 8 areas of code that are field preempted, whatever that means. And those are the Agriculture Code, Business and Commerce Code, the Finance Code, the Insurance Code, the Labor Code, the Local Government Code, Natural Resources Code, Occupations Code, and Property Code. Massive, massive areas of law, right? The Labor Code includes such hits as paid sick leave and water breaks for people who work outside, right? The Natural Resources Code includes a lot of our beloved environmental regulations. The Finance Code includes payday lending, right? A massive area of law, although we'll get to payday lending in a little bit. But what this bill purports to do is preempt any city or county ordinances in each of those massive bodies of law. Now, this upends about 111 years of constitutional government in Texas, because written into our state constitution is the concept of the home rule city, which is allowed to pass and enforce any ordinance that state law does not explicitly preempt. So there needs to be a state law speaking to a specific subject, and if there is not, then a home rule city is allowed to put its own ordinance in place. What House Bill 2127 has attempted to do is to just preempt the whole body of law with one little bit of code that says city and county ordinances in this area are invalid, right? So there's a really open question about whether this is constitutional at all. And the Senate floor debate was between Senator Brian Creighton, who was the proponent of the bill, and Senator Sarah Eckhart, who was in opposition. She made a very compelling argument that the bill is unconstitutional. Senator Creighton insisted that it was not a departure from existing practice and that all they were doing is clarifying what has always been done. I don't believe that that's the case at all. There were attorneys who weighed in from cities across the state. The Texas Municipal League weighed in. There were a lot of very smart minds who are convinced that this is a new approach and that it violates the Constitution. And hopefully we will see a challenge from one of these cities to the constitutionality of the bill. So it would be excellent if we saw a city file a lawsuit soon attempting to get this bill declared unconstitutional so that it doesn't go into effect. Interestingly, there was some really spirited debate, both in the public debates about the bill and behind the scenes with certain lobbies over specific areas of local regulation that ended up in carve-outs. One example of those would be animal-oriented businesses, specifically puppy mills, which folks do not like, and they have been banned in a whole lot of cities. There's an explicit carve-out in the bill now for these animal-oriented businesses, meaning they can be regulated by cities and counties. Payday lenders are another one. the religious organizations, the Catholic Church and the Baptist Church specifically, were very vocal about the need to protect people from predatory payday lending. So that got a specific carve out. Also,